So, Mike, thanks for sitting down with us today. It's really a unique opportunity to talk to a high-profile law firm who represents cases related to medical malpractice, and we come with a military audience here. So we're mostly wanting to pick your brain today for anyone, an active service member, reservist, family member, anyone who uses the military medical system and has had some problems and want to talk to an attorney to see what their options are. So maybe we can start first with what are the typical reasons someone calls you when it comes to military malpractice? What are those typically? What are those cases typically?
Thanks, Ken. And so the first thing is to understand what the difference is between military medical malpractice and just general medical malpractice. And the distinction there is when you've had some type of medical malpractice that has occurred in a military hospital or some type of military medical facility. When the incident has occurred in these facilities, then it becomes a military medical malpractice claim. Now, prior to 1946, you couldn't sue the government. The government was fully immune from suit. And then Congress passed the Federal Tort Claims Act, which waived immunity in select instances. It's very nuanced, but allowed individuals to sue the government for negligence. And essentially what a medical malpractice claim is a negligence claim. And so using the Federal Tort Claims Act, reservists, National Guard, veterans, retirees, family members can all sue the federal government under the Federal Tort Claims Act for medical malpractice negligence while being treated at a medical hospital or facility. The only people that are barred from filing a claim under the Federal Tort Claims Act are active duty service members. Under the Ferris Doctrine. The Ferris Doctrine prevents active duty service members from filing claims against the federal government. However, and recently when, during Donald Trump's administration, the government passed the National Defense Authorization Act, which allowed active duty service members to bring medical malpractice claims with some limitations. Those limitations are like the Federal Tort Claims Act, there's a 2-year statute of limitations, and it can't be in a combat zone. And so if you were injured or had some type of negligence happen in a combat zone through medical treatment, you can't bring suit for that. And you can't bring the suits in federal court. That's another thing. These claims are handled through an administrative adjudication. Essentially, you marshal the facts of your claim, of your injury, what happened, and you submit your claim through depending on your branch of service, it depends on where you submit your claim. And then the government, those offices evaluate your claim and make a determination of whether or not to compensate you for that or not. Unfortunately, because we're not dealing with a judicial proceeding here, this is an administrative proceeding, there are no appeals, there are no requests for review or reconsideration. What they determine is final. And so it's important when filing for an active duty service member who's filing a medical malpractice claim to gather all the information you can, all the medical records you can as soon as possible. And then when you file your claim, to do so in a very thorough and persuasive fashion, because the goal is to persuade the government official at the office that's receiving your claim to read your claim and to agree that not only was there negligence, not only were you damaged from this negligence, but that it's warranted that you receive a financial compensation, hopefully a large financial compensation for that negligence.
So is there a statute of limitations in all cases at 2 years? Is that true for family members as well, or retirees?
Yes, and so the Federal Torts Claim Act, which is what they would file a claim under, has a 2-year statute of limitations. The National Defense Authorization Act, also for military medical malpractice for active duty services, have a 2-year statute of limitations. Now, they did have, for claims filed in 2020, they extended the statute of limitations to 3 years. But now that we're in 2021, that's gone, and we're back to a 2-year statute of limitation for those claims.
And that statute starts on the day of injury?
It starts on the day that you become aware of the negligence that caused your injury and damages. And so it doesn't necessarily have to be on the day that you had surgery and they made a mistake. I mean, if the situation is you went in to have an appendectomy surgery to get your appendix taken out, and for whatever reason they made some type of crucial mistake, and for 2 months you were, constant stomach aches, constant sick, constant problems, and you didn't discover that the reason that you thought that the reason I'm sick is I'm recovering from surgery. But here you are 3, 4, 5 months post-surgery, you're still sick, and you go back to see a doctor, and you learn during that 5 months later that the reason you're still sick and the reason you're still dealing with the problems, it isn't normal post-surgery issues. It's someone made a mistake when they gave you the surgery. Now the statute of limitations starts on that day, because that's when you became aware of the negligence that's caused your damages.
So tell me about the process here, because I would think there could be a lot of, you'd be kind of unsure if what happened to you wasn't just what, happens to a lot of people when they have a certain kind of surgery or a problem. I mean, how does one know if it was negligent or not?
Well, the best thing to do, that's a sticky question. The best thing to do is, if you're having complications of any kind, post-surgery or post-medical treatment, is to immediately seek all your medical records. Collect all of your medical records and get those as fast as possible. The earlier in the process that you can grab those and get those, because that's what the attorneys need to evaluate your claim. We're trained, and we've handled so many medical malpractice claims and we have a lot of people in our office that worked in the medical field for long stretches of time. And so we can look at the claims. I mean, a standard claim for medical malpractice is essentially a negligent claim, which has 4 elements, which are duty, breach of that duty, causation, and damages. And so in order to understand duty, the first element, there is a standard of care that the doctor who provided you service or treatment has to follow. And by looking at your medical records, we can determine whether or not they followed that standard of care. If they fell below that standard of care, then they breached their duty. Now we have the first 2 elements. And then we have to link that breach of the standard of care to causing the injury that you now have. Whatever the complaint is, how they've messed up, the breach is connected and has caused the injury. And then we have to substantiate what the damages are. And this is massively important, because we do very well at itemizing a large range of damages that, from psychological to physical to future to past, and we maximize that so that the end figure is a larger figure than a smaller one, if that makes sense. And so it's a very important component here. And so those are the 4 elements. Those are and we can ascertain all of that through your medical records. And that's why it's important to grab those medical records. We will, as soon as you get them, you talk to us through a consultation, we'll ask for those medical records, and then we'll start pouring over them. And from there, we'll be able to determine what the appropriate standard of care was, how they breached the standard of care, and how it's caused you the damages and what your damages are.
Is there any cost to talk to you guys to find out if someone has a case or not?
Never. And so all consultations with our law firm, PCVA.law, are always free. You can call us, you can email us, you can write us a letter. Preferably call us. But when you call us, you'll talk to an attorney who will walk through your situation and your claim, gather as much facts and information as they need, and it never costs you a dime. You never have to pay us for that.
So, Mike, you were in the military, and so I think you might have a sense. So here's what I'm thinking. Someone had a problem, and they're still serving in their unit, right? So they're on the military base, that the military hospital's on also. People know each other back and forth between units. How does somebody bring suit where they work in a sense, and what can they expect? I mean, how are they supposed to be treated? How do they get treated? And what's the recourse for protecting, their job and sanity during something like this?
So a couple things. Most service members who work on any particular military base do not work at the hospital. Certainly some do, but the vast majority don't. And so there's no connection to the hospital, and there's no real fear or concern that there's going to be any type of negative ramifications for filing a suit for medical malpractice against the hospital on your base. Your chain of command isn't even connected to them. For those that are, the claim that you file doesn't go to the hospital. It goes several steps above the hospital's head. And so the hospital isn't really tracking, especially top down, the fact that you filed a claim against them. The doctor might become aware of it after a claim's been filed, and the higher echelons of the hospital will become aware of it, and they'll become aware of all of the claims that have happened against their hospital. But really, because it's so far disconnected from them, they're not dealing with defending the claim so much as it's being adjudicated at several levels above their head. There's little fear and ramifications, and just from policy, because the government and the military have allowed for service members, active duty service members, to bring claims for medical malpractice, they aren't allowed to discriminate against you or retaliate against you. And so anything of that nature that happens, you certainly want to, number one, bring it to your chain of command. Let them know, because your chain of command should and will advocate for you on your behalf of that. But also let your lawyer know, because if you let us know, we're definitely going to be ringing some phones and getting that to stop, because that's completely inappropriate and shouldn't ever happen.
Yeah. So you feel like there's something tied, like you've been harmed in some way. You get a free consultation by calling you folks. You take a look at that to see if there's a case. And then in this kind of suit, how long do these normally take from beginning to end?
It really varies. The process is it's just begun, and it was, the process for a long time was stultified by the military trying to put processes in place to adjudicate these claims. And so they can be very quickly, they can take over a year. It really just depends on where you're sending the claim, which branch of service you're in, the complexities of your claim, and whatnot. One of the important considerations, though, is because we're dealing with a tight two-year statute of limitations, it's important to start the process early. Because we're not going to be in front of a judge, we're not going to have an appeal or a reconsideration or whatnot. It's important to get it right the first time. So the sooner you can get all those records and you get it to us, then we can start making your claim. And the idea is to make it very persuasive. We want the person reading it on the other side to come away feeling like, I agree, this was bad, we screwed up, and it's done a lot of damage. You want to convince them of that. And so a lot of care goes into writing your claim and marshaling the facts of what happened and how it's damaged you in such a way that you get it right the first time. Your claim typically is going to go to the Office of the Secretary of Defense, and they're authorized to award up to $100,000 for your claim. If when evaluating your claim, they determine that your award should be higher than $100,000, which happens frequently, then your claim goes to the Office of the Department of Treasury for a second review, and they will review your claim and determine if they agree and to what extent they agree that your award should be over $100,000. And from there, it can go into the millions, depending on the nature of the situation and whatnot. And if they agree, then they cut you the check.
So we have military folks on TRICARE. We have, everyone pretty much, connected to TRICARE. And in some cases, those services are being handled by civilian medical systems. they've been referred off of the base. And I would imagine that malpractice can happen there as well. What's the difference between it being a military facility and a non-military facility?
Well, I mean, that can get nuanced, and a lot of times that can be, disputed and debated between the two sides. What constitutes a military medical facility or hospital, whether or not a civilian contracted doctor or physician is an agent of the government, and to what extent. And so these can be really, really nuanced considerations, and there isn't a clear answer to that. If it's determined, or if you're taking the line that the civilian doctor that was contracted through the military is a civilian doctor, this isn't necessarily, it's a medical facility in that you've been sent there by the military, but it's not, you're not suing the government here, you're suing this doctor's office. Then the active duty service member or family or reservist, retiree, whatnot, can file a federal tort claim act through federal court, because you're not suing the government here. You're not barred from bringing a suit against a private doctor. And so there's some nuances there, and there's a lot of consideration. It's really fact specific, but there's options depending on the situation.
Okay. Is the VA any different than any other, than the military facility? Is it all under the same umbrella?
The VA would be classified, VA hospitals would be classified as military facilities.
Yeah. And then what about if you're, sometimes these are children who are harmed. So, when a kid goes through this experience, I think parents worry about the trauma of the legal, process for them. So tell me a little bit about how kids are treated through this and what to expect there.
And so if this is going through, the Federal Tort Claim Act, where it's going through federal court, kids are, you have two, abutting presumptions. One is the presumption of due process and the right to face your accuser and the right to question the person who's making the allegations. But you also have the desire to protect children and not to cause them undue harm and stress and, go after them. And so the judge, when you're dealing with children in any court, the judge is going to weigh the consideration of both of these factors and put in place various, and it's really at the discretion of the judge, and it's, again, fact specific, what is allowed and isn't allowed. Like you're not going to see in almost any court a child on the stand and a defense attorney just going after them. You're not going to see that. No, yeah. Almost no judge is going to allow that.
What about cases of death? Who is allowed to bring suit? If the military member was 22, can the parents bring suit? I mean, who has legal rights when it comes to a case like this?
And so when there is a death because of some type of medical negligence, the first thing to do is to establish an estate. And there is a personal representative of the estate. And that's the person who would bring a claim for a wrongful death in that situation. And so this can be a mother, it can be a spouse, it can be a father, it could be an uncle, it could be a grandparent. It really just depends on the family dynamics and situation. But establishing a personal representative for the estate of the decedent is the first step. And from there, it's the personal representative who brings a suit on behalf of the estate. And that's how that's handled.
I don't know if you can answer this, but when you get people who contact you and it's not negligence, are there some common things people think is negligent, but it's not? Just maybe to help someone. I don't know if that's possible, but what do you say?
Sure. So in order for something to be negligent, you have to have all four of the elements. They had to have had a duty. They had to have breached that duty. That breach had to have caused you damages. A lot of times there's a saying called negligence in the air, which is where you have a duty, a breach of the duty, but there's no damages. And so, you can look at a situation where somebody's flying down the highway at 120 miles an hour. And they say, well, that's negligent. But if they didn't hurt anybody, it's not negligent, not under the law, because there's no damages. Didn't cause damages. Now that same person going 120 that hits somebody and destroys their car and kills somebody. Now you have damages. Now they had a duty not to travel at that speed because there was a speed limit. They breached that duty, and the breach of that duty, the speeding, caused this injury. And so now you have a negligence claim. And so you have to have all four elements. And sometimes, any one of the elements can be attacked. And so sometimes there's damages, there's a breach of duty, but did that breach of duty cause the damages? And so can be a causation problem, especially if it's too attenuated, where somebody is driving on the road and crashes into the car in front of them, which creates a loud sound that makes a bat in somebody's apartment eat its young because of the loud sound. Well, did the negligence cause that? It gets a little bit squishy. Could that person who was raising bats and had baby bats bring a lawsuit against the car that just crashed for creating a loud sound that caused its bat to eat its young? That's a causation issue.
All right.
So
that makes me think you've had a case like that before. No.
No, but when you go through law school and whatnot, they go over each one of these elements and all of the various ways that only one of them can be missing, and that's an example.
Yeah. Well, it sounds like really the place that folks watching this should start with is that getting that free consultation, bringing, just getting some second advice, right, before discounting it on their end. That's really, what can you lose, right?
Well, you have nothing to lose and everything to gain. If you had a medical procedure at a military facility and it didn't go the way it was supposed to, or you're still sick, or you're still injured, whatnot, first step is start requesting your medical records immediately, all of them. Every single thing that they have, start requesting them and getting them. Then step 1A, call an attorney, call PCVA.law firm, talk to me, and we will walk through it, go over it, and evaluate the legal options and decide what the best course of action going forward should be together.
Great. Hey, Mike, thank you so much. I really appreciate that information, and keep fighting the good fight.
Thank you, Ken. Appreciate it.